Hello, welcome. I am back by popular demand. It's been about a year since my last video, but I'm back, so I hope you guys are happy. And to kick things off, we're going to start by looking at constructive trusts in cases of fraud. So a constructive trust is imposed where property is gained through fraud, where a criminal or a person not convicted of a criminal offence acquires property by means of fraud. The fraudster will be required to hold that property that he or she acquired on a constructive trust for the original owner of that property. And we see this in the case of Rochefoucauld and Usted from 1897, which we're going to take a look at in a minute. Basically, the idea here is that under the general principles of a constructive trust, it would be unconscionable for the fraudster to retain that property he or she acquired by the fraud. And we see this in the case of Westdeutsch, Landesbank and Islington from 1996, unless the victim acquiesced in the fraud. In other words, he kind of agreed to it in some way, as we see in the case of Lonro and Fayed from 1992. So what does fraudulent conduct include in this context? Well, it can include a whole range of things, and it's pretty difficult to narrow down. Like, it can include representing to the occupant of a cottage that she will be entitled to live in that cottage for the rest of her life, and then seeking to evict her, like as we've seen in the case of Bannister from 1948, which we'll take a look at in a second. And at the other end of the spectrum, there are forms of fraud which will constitute criminal offences, such as obtaining pecuniary advantage by deception, which will also be recognised by equity. But if there is a fraudulent misrepresentation, the constructive trust will not arise unless the contract is voided. Okay? So, in other words, if they committed this fraud by fraudulent misrepresentation, the constructive trust will not arise unless the contract is voided. And we have this quote here from Millet from Lonro and Al-Fayed, which went, "A contract obtained by fraudulent misrepresentation is voidable, not void, even in equity. The representee may elect to avoid it, but until he does so, the representer is not a constructive trustee of the property transferred pursuant to the contract, and no fiduciary relationship exists between him and the representee." Okay, so because the transaction procured by means of fraudulent misrepresentation may be affirmed by the victim of the fraud, it is held that there ought not to be a constructive trust imposed over the proceeds of the fraud, because that would then preclude the right to affirm the transaction. Okay, and this principle here was actually affirmed in the case of Citerio Menswear from 2002. Okay, so basically in that case, two directors acquired land for which they paid £250,000 with funds supplied by the company. This transfer of money was in breach of the rules in section 330 of the Companies Act 1985, which I believe is now section 197 of the Companies Act 2006, governing loans to company directors. The company subsequently went into insolvent administration. So it was held that a director would not automatically be a constructive trustee of monies loaned to her by the company in breach of the statutory code, because such a loan could be made for proper purposes. The effect of the Companies Act prohibiting such loans was merely to make them voidable, not void. Therefore, the loan would not found a constructive trust automatically, because the company may choose such to affirm the loan subsequently. But anyway, let's now go back to the main point, that generally a constructive trust will be imposed where property is gained through fraud, by taking a look at the case of Rochefoucauld and Usted from 1897. In this case, land was transferred to the defendant on the understanding that it would be held on trust for the Comtesse de la Rochefoucauld. However, this was not actually put into writing, and the defendant later mortgaged the property. So the Comtesse subsequently sought a declaration that the defendant held the property on trust, but the defendant argued the trust was not enforceable due to a lack of writing. Okay, so it was held that equity will not allow a statute to be an instrument of fraud. In other words, you cannot use a statute to satisfy your fraudulent behaviour. So for the defendant trustee to have, relied on the statutory formalities for the creation of a trust in land would have been to perpetuate a fraud on the claimant for whose benefit that property had been acquired. Okay? So to deny the existence of the trust would amount to a fraud on the Comtesse, and therefore the trust could be evidenced by oral evidence. As Lindy said in this case, that the statute of frauds does not prevent the proof of a fraud, and that it is a fraud on the part of the person to whom the land is conveyed as a trustee and who knows it was so conveyed to deny the trust and claim the land himself. Put another way, it would be unconscionable to let the defendant keep the land, as we cannot let knowing individuals keep the benefit of their fraudulent behaviour. Similarly, in the case of Lias and Prowser from 1982, a mortgager here sought to deal with property in contravention of the mortgage on the basis that the mortgagee had failed to register the mortgage. And it was held that the mortgager held the property on a constructive trust for the mortgagee nevertheless, because the mortgager had undertaken in the mortgage contract to respect the rights of the mortgagee. Now let's take a look at another case. This is Bannister and Bannister from 1948. So in this case, Miss Bannister inherited 2 cottages when her husband died, including the cottage she was currently living in. And she then transferred the properties to her brother-in-law for under market value, but they already agreed she would remain in the cottage she was currently living in rent-free for life. However, he later tried to kick her out, which isn't particularly nice. And now the court held that the brother-in-law held the cottage on a constructive trust for Miss Bannister, who held a life interest in the property and could remain there rent-free. It was said that Miss Bannister only agreed to sell the property at an undervalue because of the undertaking that she could remain there, and it would be fraudulent of the brother-in-law to insist on the absolute character of the conveyance to defeat Miss Bannister's life interest. So there was a trust of land despite it not having satisfied the requirements of Section 53(1)(b) of the Law of Property Act 1925. Finally, before we wrap up this video, Lord Millett says something pretty interesting about this area of law in Paragon Finance and Thackeray from 1999, where he said, "Equity has always given relief against fraud by making any person sufficiently implicated in the fraud accountable in equity. In such a case, he is traditionally, though I think unfortunately, described as a constructive trustee and said to be liable to account as a constructive trustee." Basically, his point here is that it probably isn't entirely accurate to call them a constructive trustee in these fraud types of cases. You see, such a person isn't actually a trustee at all, even though he may be liable to account as if he were one. So yeah, I'm not going to go into too much detail here, but it's probably worth checking out the judgment of the case if you want to read more about what Lord Millett is saying here. Anyway, that is about it. I hope you enjoyed my first video back after quite a long time. If you want to find out more about what I'm doing, you can see my socials, my website, and my personal YouTube channel. On my personal channel, I also talk about other general tips, tricks, and advice for thriving in your law degree. So hopefully I'll see you over there as well. See you soon.